Welcome to this edition of East Texas Dirt Law. It's been a bit since I've posted. Forgive me for the delay. I think the last time I posted was on the 4th of July. And I wanted to talk to you a little bit today about real estate law, and a common misconception that I think a lot of people have, and a question that reveals that misconception that we get a lot. And if you'll forgive me for using the reading glasses, because in order for me to read my notes, I've got to have these. The common misconception we get is about deeds. What is a deed, and how does it reflect in someone's title to real estate? And the questions we get that reflect that misconception is, one question is, I want my own deed. Give me my deed. And the other question is, can you give me my own deed? In other words, people may have gotten title through various mechanisms. I'll give you a couple of examples. Brother and sister inherit property from mom and dad. Brother and sister maybe inherited 100 acres from mom and dad. They got that through a will. They got that through maybe an intestate succession, through an affidavit of heirship, through maybe even a ladybird deed, or even perhaps an estate administration. But for whatever reason, they inherited that property 50-50 from mom and dad. Another example is just two individuals, say Joe and Bob. Joe and Bob bought a piece of property together. Let's say they bought that same 100 acres. They bought it from Frank. Joe and Bob bought it, and they own it 50-50, each have an undivided 1/2 interest. So instead of each having their own deed, they're going to have one deed where Frank conveyed to Joe and Bob. Another example is just Bob. Let's just say you've got one buyer. He owns 100 contiguous acres of land, but let's say he bought it in two separate transactions. Bob bought it from Frank, 50 acres 10 years ago, and then 5 years later, the next 50-acre tract next to him, he bought from Steve. So he's got 100 acres, but he bought it in two tracts. He doesn't have one deed, he has two deeds. He had a conveyance from Frank and a conveyance from Steve. So that's some examples that we're going to be showing, kind of talking through today about what it means to have a deed and what a deed really is. The first question, or the first thing I guess we need to deal with, is define what a deed is. And interestingly enough, the Texas Property Code doesn't really have a succinct definition of what a deed is. But a deed, through Texas case law, the most concise definition I could come up with was a written instrument that conveys an interest in real property from one person, that's the grantor. You're going to hear that term a lot, grantor, to another person, that's the grantee. Grantor is the seller or the person conveying the interest. Grantee is the buyer or the person receiving the interest. You can have multiple grantors or grantees. Brother and sister may sell the property. They're going to have there's two owners, therefore there's two grantors. And you may have multiple people buying the property. In the example I used before with Joe and Bob were two grantees, but you could have multiple. You could have 7 or 8 grantees. You could have 7 or 8 sellers. We have that come up all the time. Since all that's required in the conveyance of an interest, all that is required is the conveyance of an interest, there may be a deed that conveys a fractional interest only. So you may have a deed that conveys only a half interest or a 1/4 interest in a piece of property. And consequently, you may have a deed that conveys the whole ownership of the property, the whole 100%, but does it in fractional interest. They may convey this 100 acres to 4 different people. So each of those 4 people have a fractional interest, each owning a 1/4 undivided interest. And when I say undivided interest, this is one of the more, it's a hard concept to understand, but the best way I can explain it is, if you own an undivided interest in real estate, think of whatever real estate you're talking about. I've been using 100 acres as an example. If you've got 100 acres of real estate and you own a 1/4 undivided interest, every square foot of real estate that comprises that 100 acres, you own 1/4 of that square foot. So every single square foot that's out there, you own 1/4 of that square foot. That's if you own a 1/4 undivided interest. If you own a 1/2 undivided interest, you own 1/2 of every square foot. So you don't own a particular 50 acres out of that 100. You own a half of the whole thing. That's called an undivided interest. So a deed is not like what most people think of as a deed is they want their title. I want my deed. They think of a deed as like a car title. A deed is not a car title. A deed shows a conveyance. In other words, you may have a title. Title may be done by examining several conveyances over the years. You may have, again, one person owns a half interest. 5 years later, somebody else acquires a half interest. So the particular property, you've got two half interests, both were conveyed in deeds at two different times. And that's largely what we do when we do title examination. We're examining the conveyance history of a property over time, coupled with heirship records and things like that. So in summary, again, a deed is an instrument of conveyance. It's not a title. It's not a single snapshot picture of a title. And your title to real estate is simply is an examination of the multiple deeds of conveyances, or maybe even affidavits of heirship, or deeds out of an estate, or whatever that show the conveyance over a particular time period. I hope that clarifies what a deed is. Now I want to talk about the different, what Texas courts talk about when you say what a valid deed is. And this is important because we see a lot of deeds. Every title examiner will tell you, you see a lot of deeds that aren't really valid deeds, and that causes curative work to have to be done in order to close a real estate transaction. What Texas courts have said, in order to have a valid deed, you've got to have an instrument. Number one, it has to be in writing. It can't be a verbal conveyance. It can't say, I give it to you. If somebody says, I give you 100 acres, that is not a valid conveyance. It has to be in writing. The interest has to be conveyed. The interest to be conveyed has to be sufficiently described. Am I conveying to you all of the property? Am I conveying to you only a 1/2 interest or a 1/4 interest? Am I conveying you all of the interest, but am I reserving back some things? And there's reservations that can be done in deeds. We'll talk about that probably on a later podcast. The real property itself has to be sufficiently described. This is really important. We see a lot of deeds where the property itself is not sufficiently described because the common mistake is people use the description that is in place at the tax office. The tax office doesn't have, they use an abbreviated version, and they'll say X number of acres out of a certain abstract, and then they'll have some sort of a code attached to it. That's not a legal description. A legal description is the full meets and bounds description. I'm talking now about rural real property out in the country, not in the city in a platted subdivision or a city lot and block. But when you've got 100 acres out of out in the country, rural real property, RURAL, real property, you have to have the exact meets and bounds description that a surveyor would give you. That's not a picture. Picture's okay to attach to it, but you have to have the words showing the distances, the angles, the measurements, so I can take those words and I can actually go out on the ground and find the property that we're talking about. That's what you have to have in the deed to have a valid legal description. Again, if it's in the city or in a platted subdivision, you can just use a lot and block description. You don't have to have the full meets and bounds description. Another thing you have to do is identify both the grantor and the grantee sufficiently. You've got to be able to read the deed and ascertain who is selling and who is buying, or who's the grantor, who's the grantee. Another thing that deeds have to have, and this is really, really important, there are title companies in this area, I've seen them, I've read the deeds from them, that produce deeds in a real estate transaction that don't have what's called operative words of grant. You've got to have an operative word of grant showing that their grantor has an intent to convey an interest in real property. Typically the words you're seeing are grant, sell, and convey. I hereby grant, sell, and convey this 100 acres to whoever. Or I have, by executing this deed, granted, sold, and conveyed the property herein. That's really important. I see a lot of deeds that don't have it. I think a lot of people would rely on the fact that it just says on the top, it's a deed. That may be the case, but the deed does not itself say grant, sell, and convey. I see that mistake a lot, which really surprises me, but you do see that mistake. And the last thing is a deed has to be signed and acknowledged by the grantor, not the grantee. Grantee does not have to sign a deed. The grantor, the one selling it, has to sign it, and it has to be acknowledged. That means it has to be notarized. Last thing I wanted to do with you is to talk about the basic kinds of deeds that we see in real estate transactions in Texas. If I listed every kind of deed that we see, we would be here for hours. But there are 4 commonly used deeds that we deal with and that you'll see mostly in transactions. The first one, and the one most commonly used, is called a general warranty deed. And I'm going to read you the definition and I'm going to explain it. The general warranty deed, again, that's the most common form of conveyance that you'll see, is a deed that conveys an interest in real property in which the grantor covenants to warrant and forever defend the conveyed title, conveyed title against all lawful claims of all persons, regardless of when the alleged title defect arose. I'm going to read that again because I kind of botched it. Deed conveying an interest in the real property in which the grantor covenants to warrant and forever defend the conveyed title against the lawful claims of all persons, regardless of when the alleged title defect arose. Simply stated, that means I'm promising you that it's mine, and I'm promising you that I have the right to sell it to you. And if those 2 things are not true, I will step up and indemnify you and defend you in court. That's the warranty on the deed. That's a broad warranty. You see that mostly in real estate transactions, but sometimes you'll see a deed called a special warranty deed. That's the second most commonly used instrument. And a special warranty deed is a deed where the grantor warrants the title only against the defects, claims, or encumbrances arising by, through, or under the grantor, but not otherwise. What that means is the grantor is not warranting all the warranties through back in the chain of title. They're only warranting back through themselves and no further back. Those deeds typically are okay, especially when you have a transaction that's going to close with the title company, because as the title company, we're willing to insure that deed because we've done the title examination back way further than just the grantor. So we're willing to honor that. You'll see a lot of sellers, especially institutional sellers, in commercial transactions, they don't want to do a general warranty deed. They only want to do a special warranty deed. And again, we'll insure those as long as we do a full title examination. The third commonly used deed is a quitclaim deed, or sometimes just referred to as a quitclaim. This is a really misused instrument. It's very useful in the state of Texas for some things. What a quitclaim deed is it conveys the grantor's rights to the property, if any. In other words, the grantor is not saying I own it. I'm not saying I don't own it. I'm not saying anything. I'm just saying if I have an interest in the property, I'm giving that to you. Those deeds are not useful for insuring title. We can't close on a quitclaim deed because there's no promises. The only way to show that a quitclaim deed, for that to actually be a conveyance, title to the grantor has to be established by extrinsic evidence. You've got to go and prove that the grantor actually owned the property. We use those a lot just to clean up little things. For example, we may have a husband in a divorce back in the chain of title who didn't properly convey his interest out, or at least it was hazy in the record. So we'll get that husband to sign a quitclaim deed just saying, I'm not saying I own anything, I'm not saying I don't, but whatever I have, I'm giving to you. In other words, if I have an interest back in the chain of title, I'm willing to just release that. Another thing that we commonly have is homestead interest that people have. A lot of times people will inherit property and it's not where they live, but because of the Texas homestead laws, which are really complex, they may have a homestead interest in the property, and it's somebody, a spouse inherited it. Their spouse may have that homestead interest, but they didn't sign a deed back in the chain of title. So we just need that quitclaim from that spouse to make sure that their homestead interest is released. Those deeds are used to clean things up. They're not used to pass title, and we would never insure title on a quitclaim deed. You got to be really careful about using quitclaim deeds. I think a lot of people just say, hey, just do a quitclaim. That's all you need to do. That's not all you need to do. Quitclaims are very limited, useful instruments, and we can't use them to really pass title to real estate. The fourth thing, and the last deed I want to talk to you about, is a deed without warranty. A deed without warranty, it's a true deed and it passes title, but it just doesn't make any covenants or warranties of title. A deed without warranty does convey title. A quitclaim doesn't. That's the main difference. We use deeds without warranty commonly in conveyances out of an estate. If you have a personal representative, an executor of an estate, and he wants to convey property out of the estate to the beneficiaries, we'll typically use a deed without warranty because the executor doesn't have the knowledge to make those warranties about the property, so we'll limit the warranty with that. The other example or situation we use those in is when we have just a small part of a larger tract that for some reason when we're doing the title examination, we can't really link the title together. There's a problem. It's usually a small acreage, let's say 10 or 15 acres out of a larger 1,000-acre tract, for example. There may be a problem just with that particular part of it. A lot of times it's accreted land on the Red River. That's a common problem. And we'll have that seller sign a deed without warranty just to that small part of the property if the grantee will accept it. And we've cleaned up problems like that with deeds without warranties in several situations, again, if the parties agree to that. There's a whole many other kinds of deeds that we could talk about. Sheriff's deeds, that's a deed that you get from a tax sale or an execution sale. The trustee's deed, that's a deed that you get from the courthouse after you buy property at a foreclosure or a trustee's sale. Ladybird deed or transfer on death deed, those are deeds commonly used in estate planning. Ladybird deed is a deed with a reservation of an enhanced life estate. Transfer on death deed is just a deed that only takes effect after the death of the grantor. Another couple of things is a gift deed. That's a deed that simply evidences a gift of property. And a partition deed, that's a deed where commonly owned property is divided among the common owners. That's an example of a couple of other deeds that we see commonly. I could go on and list probably 20, 30 more that we see a lot of. But I wanted to just go over deeds, what they are, what the different kinds are, and really what it isn't. A deed is not a snapshot in time of title. A deed is an instrument of conveyance. There may be multiple conveyances that show what your title is or your title isn't. I hope that helped you. I hope that taught you a little bit more about deeds than you knew before you started this podcast. As always, this podcast is for information only. If you need legal advice, all cases, all situations are different. Go seek competent counsel. Come see us or any competent lawyer and talk to them about your particular facts and circumstances. But I hope this general information helped you. Hope you learned something. And let me know, make comments, send emails to me, alan@goodingtitle.com. Go on the comments on the YouTube page. Let us know what you'd like to hear about. If this one was boring, but there's something you do want to hear about, let me know. And we'll talk about those things. But I look forward to seeing you next time on East Texas Dirt Law. And thank you for the time.